first case on this morning's docket in the matter of the estate of Lorine H. Mueller, case number 127532, and counsel, you may approach.
May it please the court, Clark Grant, Nebraska counsel here on behalf of appellant Cheryl Mueller. Chief Justice, I would like to reserve 3 minutes for
3 minutes is reserved. Thank you.
Well, it's been a long journey. I've been working on this case since 2014. Lorine Mueller died in 2017, and so we're actually 9 years out from the date of her death. And I'm hoping that this is the last court we appear before. We counted this morning, and I think we've been in 7 different courts, 2 different states, county, district, Court of Appeals and Supreme Court of Nebraska, District Court of Kansas, Court of Appeals of Kansas, and now here we are in the Supreme Court. Before I launch into the argument in my brief, just for some context, I want to refer to some of the prior litigation and reported cases. Lorine Mueller's estate plan that was put forth in her 2007 will has essentially been attacked since Margot Loop became Lorine Mueller's court-appointed conservator and guardian back in 2014 under an order from the county court of the state of Platte County, Nebraska. In 2014, shortly after she was appointed, Margot Loop sought to sell all of the assets of Lorine Mueller in order to arguably support her and her nursing care. That included the home where my client had lived with her husband, Randy Mueller, the son of Lorine Mueller, since 1976. Of course, we didn't want the house to be sold, and the house was to be bequeathed to my client, and according to Lorine's 2007 will. The probate court in Platte County ruled against us, said it was okay to sell all the property. We appealed that decision, went to the Nebraska Court of Appeals with the argument that the conservator has to take into account Lorine's estate plan before she determines which assets need to be sold in order to support her care. Court of Appeals determined that there were plenty of other assets that could be sold in order to support Lorine's care, and because of the estate plan, did not allow Margot Loop to sell Mucow, which is where the farmhouse is, where Cheryl has lived. And 4 months after that decision, Margot Loop again filed the same motion before the probate court in Platte County. Again, the Platte County court ruled the same way. We filed an appeal in that case. And the difference, though, between the 2 occasions is that in the meantime, we entered into what we now call the settlement and mutual release agreement, which is primarily what we're here to talk about this morning. Cheryl gave up a lot of rights when she signed the settlement and mutual release agreement, including the right to have any objection or have any standing on further matters in the conservatorship case. And so the Court of Appeals, despite its ruling 4 months prior to the district or the county court's ruling, said, sorry, you don't have standing to be here. We lost that appeal. And of course, the next step would have been to sell Mucow, which would have probably ended the case. However, before that order came back from the Court of Appeals to the county court, the probate court, Lorine passed away and the conservatorship ended. Then the very day that Lorine passed away, Margot Loop filed a probate action in the District Court of Sedgwick County. And in that probate action, she sought to probate a will that Lorine Mueller had executed in 1979, 38 years prior to her death. Of course, there had been 2 wills that she had done in the meantime, including the 2007 will, which was filed for probate in Nebraska. Eventually, we had a will contest that played out in Sedgwick County District Court. That case was decided against Margot Loop in favor of Cheryl Mueller. Margot appealed that case, went to the Kansas Court of Appeals. Kansas Court of Appeals affirmed Judge Rumsey's decision that the 2007 will is the one to be probated.
Counsel?
Yes.
At the risk of, I don't want to interrupt you in your procedural history, but maybe I can fast forward you a little bit. So we have a district court, a state proceeding in Sedgwick County that initially grants the right of set off. But then there is an ancillary probate proceeding in the state of Nebraska. And judgment is issued in Nebraska in that ancillary probate proceeding. And then back in Sedgwick County on reconsideration, the set off is denied. Is that a correct summary?
That's very accurate. Judge Rumsey, I think on two occasions actually ruled in favor of Margot Loop on the set-off issue, but he never went forward with those orders because he knew that the litigation was still pending in the state of Nebraska. He said, let's wait and see what Nebraska does. When he found out what Nebraska did, then he followed suit.
And it's the Nebraska piece that I wanted to focus in on a little bit. In that ancillary probate proceeding, which is really settling the property that is located and situated in the state of Nebraska, as opposed to the personal property in the state of Kansas, the district court interpreted the relevant provision, Section 5 of the settlement agreement. Is that correct?
I would say so.
Yes, and they ultimately held that that provision barred collection, whether that be direct or in the form of a set off in probate.
That's correct, and that's pursuant to the Nebraska Probate Code, a very specific section of the probate code.
Well, I mean, irrespective of the probate code, I mean, it's essentially a contractual interpretation that says essentially that the estate has released whatever right it had to set off. I mean,
Correct.
that's the practical effect.
I would say I would agree with that assessment. Yes.
Okay. All right. Now, then when we get to the Court of Appeals decision in Kansas, does the panel's holding essentially create two then different interpretations of that same contract?
I would agree that it does. And I would also submit that the parties in the settlement agreement, the contract, agreed that Nebraska law was going to determine any dispute about how to interpret it and any effect of that. I'll call it the Nebraska $240,000 judgment. And so I don't think it's appropriate for Kansas to say, no, we're going to interpret that contract differently. It's just a matter of contract interpretation. The parties agreed to the law of Nebraska being applied, and Nebraska has applied that law and shown that it is not subject, that's judgment is not subject to a set-off order.
And essentially your position to our court is that we should give deference to that judgment in Nebraska.
Correct. And I would also point out quickly too, another main part of my argument is that this is not a case like the Warnett case where it was simply an obligation that was unpaid at the time of the decedent's death. This was a contract where a portion of the contract had to do with settling the lawsuit against Cheryl Mueller that ended up in the Nebraska judgment. But there were, I quote extensively from Judge Krotzl's opinion in the probate court to show what else was involved in that contract. And we've given full consideration for the estate's agreement not to enforce that judgment. And I would submit we've given more than $200,000 or $340,000 worth of consideration. So to say that this is just like Warnett is absolutely dead wrong.
And can you give me an update, because I wasn't entirely clear on the record. What is the status of the ancillary probate proceedings in Nebraska? There's obviously a final judgment in that case, but were there subsequent appellate proceedings?
No, there was no appeal. And so that case is the law in the state of Nebraska. It's the law in this case in terms of how Nebraska views it. I was actually shocked that we didn't have an appeal on that case, but we did not. So that's the law of the land, the law of the case.
Thank you.
I don't know if the 3 minutes incorporates my rebuttal. It does not, so I can continue.
Go ahead.
Very good. Again, and then I would like to, I guess, talk briefly too about if we do get to a choice of law analysis, I think the Court of Appeals took a left turn there as well, and a U-turn the wrong way. This case is the analysis of the court was that, well, we have to determine whether this is that set off is a substantive right or a procedural right. And the court said it's substantive or it's procedural, but cited no case law for that proposition. And in my brief, you'll see I cited a number of cases, a number of Kansas cases, a Nebraska case that indicates that the concept of set off is a procedural right that's bestowed upon litigants. It's not a procedure. So if you look at set off as a substantive right, then you should look at the law where the right arose versus the foreign state, which would be the state of Kansas. So our argument is that the Hogan case that was cited by the Court of Appeals in support of its positions actually supports our position on that issue.
Well, if the conflict is substantive, what doctrine do we turn to? Do we look to the restatement first of probate as opposed to contract, right? Or are you advocating a different set of rules to govern that?
I think that leads into my final point about the restatement. The Court of Appeals said, well, we don't follow the second restatement. So I cited the second restatement in support of the proposition that if the decedent puts in their will that I want the rights to be determined by the state of Nebraska, that should be followed. The first restatement is silent on that matter. It says, well, it talks about domicile and all those sorts of analysis, but the first restatement is absolutely silent on the issue of, well, what if the decedent puts that specific clause in their will, which was done in this case. And it isn't a clause that talks about construing the will or construction as the appellee wants you to believe. It's a clause that says all of the rights under this will are going to be determined by Nebraska law. And so.
And would the rule you propose be subject to a caveat unless that choice of law conflicts with the public policy of?
And that's the final argument. And I think my public policy argument is like this.
But you would acknowledge that exception exists in the rule you propose. You just don't.
But I don't think we ever get to that public policy argument if you follow the analysis that I've put forward. And even if you do, I think the public policy of protecting a person that was living her life for 94 years in Nebraska, suddenly domiciled in Kansas, I'm not following what public policy is in play to support protecting her. And it's like you're protecting her against herself. Yes, she's now a Kansas resident, but she was a Nebraska resident for 94 years. She wrote her will in Nebraska. All of her property is in Nebraska. But for the formation of a corporation, we wouldn't be here because if the corporation didn't exist, it would be real estate in Nebraska, not subject to the jurisdiction of personal property in Kansas. So thank you.
Counsel, before you step away, I have a quick question. What do you make of the line in the settlement agreement, which the Court of Appeals, in my reading of the opinion, really latched onto, which is that the confession of judgment shall not be forgiven? And the Court of Appeals obviously
we addressed that. We addressed that directly in our brief. I was representing Cheryl Mueller when we entered into that agreement, and that was to be perfectly honest with you, and we've stated in the brief, that line was put in there because we knew that Lorine Mueller wanted to take advantage of this judgment and claim it as a deduction on her income tax return. She had sold a bunch of real estate in Nebraska, so she had capital gain tax problems. She was able to use the $340,000 judgment as a set off or a deduction, if you will. And we knew that going in. And so that line is in there to address the IRS issue of, well, are we just playing games here? Well, no, let's say.
Well, why doesn't it have, couldn't it be a double-edged sword?
Obviously, it was not a good idea for me.
So my legal question for this case is, why is the Court of Appeals wrong, from your perspective, to give this provision legal weight in the current dispute?
Well, so for all of the reasons of the other argument, I base it heavily on the consideration argument. Yes, Cheryl got the benefit of not having the judgment collected, but she gave more than adequate consideration for that. So whether the judgment is forgiven or not, it's clear
Your
that it was
argument
never
is
to be
that
used.
even though the contract says shall not be forgiven, that it's effectively not a debt because she paid it.
I agree. That's our position. And I understand that that's hard to square, but
Yeah.
that is in fact the case.
Okay.
Thank you.
Wait a minute. Any other questions, colleagues? Okay, thank you. You can be seated.
May it please the court, my name is Michael Jelka and I represent Margot Loop and Gary Mueller, who are the two surviving children of the late Lorine Mueller. Now, Kansas law since 1902 holds that when an heir owes a debt to an estate, the amount of that debt plus accrued interest must be set off against that heir's distributive share of the estate. In this case, the estate holds a $340,000 judgment against Cheryl Mueller. And our view is that a judgment, even if not collectible.
Counsel, I'm sorry to interrupt you so early on, but you just stated sort of the controlling legal principle
Yes.
that you're relying on this right to set off, which is a common law doctrine that dates back for a very long time in our state, right? But you, and it seems that the panel uses the word must be set off. And I wanted to probe that a little bit deeper because would you agree that it is this right of retainer, or what we've been calling set off for shorthand? It's an equitable doctrine, correct?
It is, Your Honor.
And so when an administrator and then upon review by the probate judge is assessing it, they're considering equitable circumstances and then making a decision about whether it's equitable to do a set off.
Sure. And in this case, a judgment certainly represents an obligation to pay. Even though the parties here agreed not to have it collected, they did, as Justice Stiegel's question suggests, said it's not forgiven. So I would submit to the court that equity requires the court to apply that.
Right, I understand the equitable arguments both ways, or there are equitable arguments potentially both ways, but it's really sort of a factual inquiry based on all the equitable circumstances that may exist in a particular case.
It is an equitable doctrine, and I would concede that.
Okay.
Now,
Would that include conceding that if the facts demonstrated that the judgment was effectively paid off, would the equities weigh against allowing the set off?
I'm not sure how what effectively paid off here. If this,
Well, that's my understanding of your opposing counsel's argument.
well,
Look, we paid for this.
let me address that. He addressed this tax return issue, and this is not in the record, first of all. And second, there's a clause in the settlement agreement that specifically states that this agreement supersedes all prior promises made and may not be modified except in writing signed by the parties. And what he's trying to do is introduce an affidavit that's not in the records, not signed by us, to modify the terms of the agreement and effectively forgive the judgment. We don't think the court can do that pursuant to the terms of the
I guess
agreement.
that goes directly to what I understood Justice Wall's question to be, which is this a question of law decided within the four corners of the agreement, or is it an equitable question which might be subject to additional fact finding?
Set off is an equitable doctrine. I acknowledge that. The Wernet case says that. But in this case, there is no dispute here that there is a judgment in effect that is explicitly agreed to by the parties. It shall not be forgiven. That's my assessment. Now, I want to respond to some of the questions that Justice Wall asked.
Before you move on to those, I did have one other question about a provision in the settlement agreement that I don't think got much discussion in the lower courts, where I'm sorry, I don't have the section specifically, but essentially all the parties, which is often standard language in a settlement agreement, dispute factually the existence of any debt or liability. And in fact, expressly disagree that any indebtedness is owed to the other.
Yes, that's a pretty standard clause in settlements.
How do we read that clause in provision in conjunction with Section 5?
Okay, but it does not in any way, that clause, take legal force away from the judgment, Your Honor. I understand that she denied it, but it's still, she is confessing judgment, and that confession still represents a debt in our view.
That document sort of trumps
Yes.
that more generic language.
Yes. Now,
The
you
fact
asked.
that both of those are in the document, does that render the document ambiguous?
No, there's nothing ambiguous about the judgment, Your Honor. She's confessed judgment in the amount stated in the document. And the settlement agreement that accompanies the document says the judgment is not forgiven. Therefore, it's a valid judgment, represents a debt. Granted, the document bars the remedy of the estate can't
That's what I'm
sue.
saying. Doesn't, I mean, to me, that's pretty ambiguous.
There is a distinction that Kansas law and even Nebraska recognizes between collection and set off. The one is, shall I say, offensive, and the other is defensive. In this case, the estate is not suing Cheryl Mueller to try to collect anything. It's just using the amount of the judgment defensively to just offset against her distributive share of the estate. If there was no money in this estate, if Lorine Mueller had spent every penny she had, the estate couldn't do anything to Cheryl Mueller. It can't sue her. She has a defense in a legal action to collect the judgment. But that is, and I think it's very clear from the holding in Warnett, that collection and set off are distinct concepts. And the fact that she has a legal defense is no different than the situation that Clifford Fry, the nephew in the Warnett case, was in. He had a legal defense to the collection of a promissory note, $15,000 promissory note. But this court said in Warnett that does not end the matter, and goes on to say that set off is an equitable doctrine, and that even though the person has a legal defense to collection, that does not bar a set off against their distributive share of the estate. Now, if I can take back to your question, you asked, Justice Wall, you asked the opposing counsel about this Nebraska probate case. The Nebraska case was adjudicating land up in Nebraska, and it was very explicit in its opinion that we are not expressing any view, or we're not adjudicating these assets that are under control of the Kansas court. The difference here is because Nebraska has a probate statute that allows for the assertion of this defense, this statute 30-24101. Kansas does not have that. In Kansas, the law is Warnett or Holden in its progeny. So that decision in Nebraska has no preclusive effect upon the issue before this court, where we don't have that statute.
Well, could you read that district court decision? I mean, it did interpret the settlement agreement that we're talking about today, correct?
You did reference it, yes, yes.
And it interpreted and it defined what collect meant under the agreement. And it concluded that barred, the plain language barred any recovery, whether through direct or set off.
Well, the way I'm reading the Nebraska County Court decision, it's relying upon this Nebraska probate statute and recognizing that in the settlement agreement that Cheryl Mueller can raise this defense of collection. But I don't think that binds a Kansas court, which after all is applying a different set of rules where we don't have this statute. So that's my rejoinder to.
But what about the fact that the will itself says, not Kansas law, everything needs to be construed under Nebraska?
And I would say two things to that, Justice Standridge. First, I would say that a provision in a will can't displace Kansas procedural law, which directs the disposition here. And second, I want to urge the court to give careful consideration to the New Hampshire Supreme Court's decision in In re Estate of Dow, which presents the same factual scenario. In that case, as in this case, you have a testator who in state one executes a will that says, administer my estate according to the law of state one. And in both cases, the testator then moves to state two and becomes domiciled in state two. So the question that is presented to the New Hampshire Supreme Court is the same one that's presented here today. Does states one law or does states two law applies? And the New Hampshire Supreme Court says state two's law applies here. And in reaching that holding, the court draws a distinction between rules of construction on the one hand and what it refers to as the state's conclusive rules of law on the other hand. And says a testator can select the state to be applied for the construction of a will, but not for what the substantive law is.
But why isn't this substantive? Because it affects an equitable right to, who's entitled to the estate assets. It's not just a court procedure.
Well, we think the substantive right here is the debt itself. The set off is simply the procedural mechanism to distribute the assets of the estate. And I would say this, Your Honor, this kind of goes in hand with the conflict of laws problem that I want to address, and it's sort of goes hand in hand with Justice Wall's question earlier, that we think that Kansas law needs to apply here because, and if I can point out that what we think is really the fundamental flaw here of the other side's position, if you look at pages 11 and 12 of their brief, they say that if a conflict of laws issue is a matter of procedural law, the law of the forum state is applied. We agree with that. I think the other side agrees with that, and that's certainly the Court of Appeals view. But then they go on to say, if the conflict of laws issue is a matter of substantive law, then the law of the state where the cause of action arose is applied. We disagree with that. And we think that runs counter to your decision in Higdon. In Higdon, you pointed out here at page 578 of your opinion that if it's a substantive matter, the category of substantive law will control what law is applied as different rules apply to different legal categories. That is to say, you have one set of rules for tort, another set of rules for contract, and another set of rules for probate. In this case, we think the applicable probate rule is, under the first restatement, is section 306, which says, apply the law of the state where the land is located for real property, and in personal property dispositions, apply the law of the domicile. And the Court of Appeals sets forth this rule at page 14 of its opinion.
Can't decide to, we've in the past have adopted the restatement, the first restatement, but that's not what the second restatement says.
That's true.
We would come to a different conclusion if this court today decided to adopt the second restatement.
No, I do not agree with that. I think that even if this court wants to use this case as a vehicle to abandon its longtime reliance on the first restatement and follow the second restatement, you reach the same result, because after all, under section 263 of the second restatement, that says apply the law of the domicile when distributing personal property.
Didn't this will include more than just a choice of law? I mean, I'm following up on Justice Standridge's questions here. Without regard to my domicile at death, Nebraska law shall govern the rights of all parties interested in my estate and the validity and construction. That's pretty clear, and at least in my mind, is what is supposed to happen and what law is supposed to apply regardless of where your client resides. And
just hanging on to that is that the only reason she ended up in Kansas was after she was in a conservatorship. So, so there was no change of mind. Which is the other case that we were talking about. I'm going to move now. She was moved, because of a conservatorship.
Which happens all the time. I'm trying to understand your position here is why that specific language just doesn't control.
Our position, Your Honor, is that a testator can select the rules of construction that are to be used and the in re state of Dow case drops a footnote and says that refers to the meaning of words. Now, what a testator cannot do is select a substantive law to be applied or displace the forum state's procedural law. That's the clear import of the holding here in In re State of Dow, which we are urging this court to adopt. So, then I finally, the final point I want to make, because I have 42 seconds left, is I want to refer to the strong public policy argument that even if the court finds that this choice of law provision in either the settlement agreement or the will is controlling, Kansas still holds that the strong public policy of the state can override a party's choice of law provision. And the Court of Appeals opinion, page 23, describes Holden and its progeny as, quote, a fundamental equitable policy. It's been ingrained in Kansas law for well over a century. It has been interpreted so broadly that even like debts discharged in bankruptcy are still subject to a set-off. So it's our position that even if the court were to accept the idea that the testator's choice of law provision should be upheld, that the strong public policy of Kansas ought to override that.
Can I ask you about that the set-off doctrine? And I think, as I understand your position, is that it sort of survives any and all defenses. Our case law has really sort of focused on procedural defenses like statute of limitations won't bar set-off. Do you think it's a different question if the parties, hypothetically, had previously settled and released their specific right to set off?
Well, of course, in our case, there was no discussion.
Just hypothetically, if that were the situation.
I suppose that could factor into the analysis, Your Honor. I can see that. Now, I would say, though, in response, though, here, recall that the Court of Appeals opinion notes that even debts that have been advances, actually is what I want to say, advances are by statute subject to set-off. And the Court of Appeals said it's too big of a pill for us to swallow that those could be subject to set-off, and yet money that was taken involuntarily would not be. That was too big of a pill for the Court of Appeals to swallow, and I would submit that it ought to be too big of a pill for this court to swallow as well.
I want to follow up on your public policy argument. So just taking a step back, you were saying that, that the strong policy in Kansas. Okay, so we have the policy in Kansas, but when we talk about public policy, would applying Nebraska law actually violate Kansas public policy? Like, would it, in other words, the testator chose Nebraska law and the Kansas policy about repaying debts.
In terms of public policy, Your Honor, just recall this will was in 2007. That was years before Cheryl Mueller stole from her mother-in-law. Well, hundreds of thousands of dollars. I think that's the Court of Appeals describes it as involuntarily taken. So maybe stole is too strong a phrase. I can see that, and I'll pull that back.
Okay.
So
okay. Thank you.
Thank you, Your Honor.
Thank you. Anything else, colleagues?
Thank you for your arguments. You reserve 3 minutes.
May it please the court, Clark Grant again for rebuttal. I want to first and foremost say that set-off is an equitable policy. And I think that if you look at the submitted brief, that's the point we're trying to drive home. This isn't a case like Wernette, where the debt was just cut and dried, and there really wasn't any equity to apply to that, whether that was appropriate to do a set-off in that circumstance. Here, we submit that the equity of the case weighs strongly in favor of Cheryl Mueller and weighs strongly in favor of this court upholding Lorine Mueller's estate plan to do what the appellee wants you to do in this case, obliterates Lorine Mueller's estate plan. And why shouldn't she have the right to say, I want the law of Nebraska to be used in determining who receives assets from my estate? It's not a matter of construing or a matter of construction of a contract or of the will. It's a matter of, if I'm domiciled somewhere else, I still want the laws of Nebraska to determine. And Nebraska has determined the law in this case, and that is that set-off doesn't apply. The second restatement, if you adopt that, doesn't mean that you're abandoning the principles of the first restatement. Really, the second restatement has those same principles as the first, but then adds a provision to say, and if a testatrix says they want the law of another state to apply, then we're going to follow the will. And that isn't, you're not abandoning the first restatement in that regard. You're simply adding another provision for guidance to the court in a case just like this. So I think it would be very appropriate for this court to adopt the second restatement on this subject matter.
In the district court's judgment where it denied set off, are there findings or other indicators that let us know that the district court judge was exercising or viewing the equitable circumstances in reaching its holding? Or do we imply them in the absence of those findings?
I think it can be implied. Judge Rumsey's decision, as you know, he didn't spell out those equitable principles. I honestly think he looked at the contract, the settlement agreement, said they agreed Nebraska law would apply. Nebraska has now spoken, and so I think he felt the need to follow that. But
how would an appellate court review that on appeal? For an abuse of discretion?
well, I think you've got a de novo review here, and it's a law
Well, if
question.
we're implying facts.
True. Yeah. Well, then perhaps we need to remand back to Judge Rumsey to have findings of fact on the equitable principles.
Can I follow up briefly?
Yes.
Another couple questions. At the outset of your first argument, I understood you, correct me if I get this wrong, to argue in response to Justice Wall that the Nebraska court had effectively denied a set-off because it construed the settlement agreement as not creating a debt. Is that part correct? In other words, it applied principles of contract interpretation to rule that there was no debt at all.
I would say that's a fair assessment, because if you look at Judge Krotzel's decision, she says Cheryl's already paid.
Okay, so then my follow-up, I wanted to establish that, is when we were discussing that with your opposing counsel characterizes that same decision differently and suggests that no, the Nebraska court was not ruling as a matter of contract law that there's no debt. The Nebraska court was simply ruling that this debt is not collectible as a set-off under Nebraska law. So does that distinction that I'm drawing make sense? And then I just wanted to get your response to opposing counsel's argument.
If you read, I mean, it's a well thought out opinion. And I don't think Judge Krotzel would have gone through all of the terms of what the settlement agreement required my client to do. The reason she was doing that was she was showing the equity of the case. And so, yes, there was the equity of the case. And then she followed up by saying, and in Nebraska, we have the probate code that says that if the heir has a defense to the claim, she can present it. So perhaps it's a combination.
Is it fair to say that you're making arguments in the alternative? Like one alternative is choice of law, Nebraska law ought to apply, but you're also arguing that simply as a matter of contract interpretation, there's no debt.
I would agree. Correct. Yes. Thank you.
Colleagues, any other questions? Thank you, counsel.
Thank you very much.
Counsel, thank you both very much for your arguments this morning. This court will now take this appeal under advisement.